Hi, this is Robin Tull, and we are coming from the orange couch that you've become accustomed to when we want to talk about financial planning subjects. And today, I have actually a friend of mine for 40-some years, believe it or not. He's on the orange couch, and I get to ask him a lot of questions. So I'm really excited about this. Doug and I started about long time ago, and we were both working for a nonprofit organization, and he was the attorney and I was the area director. And I would meet with the individuals and talk to them about their giving, about their estate planning, and then I'd pass it to Doug, the estate planning attorney. And what's interesting, fast forward to today, we're doing a lot of that today, aren't we, Doug?
Same thing. I mean, it's kind of amazing. All these years, we both really worked hard to build teams that really provide a lot of value to our clients, to our customers. And we still have that team concept. So you and I worked as a team back then in a different venue, and we're doing the same thing now. We have different roles, obviously. I'm on the legal side, you're on the financial management and investment side.
Right.
But we work very closely together, and we've always done well together that way.
Well, when you think of estate planning, I always have been told, and I told clients, if you don't have a will, the state of Virginia has one for you. That's really the truth, isn't it?
Oh, absolutely. And people don't realize that. A lot of times people say, well, they assume everything's going to go to my kids or everything's going to go to my spouse, but it really depends on a lot of different factors. And if you don't have a plan that you put in place yourself, then the Commonwealth of Virginia already has a statutory scheme that allows distribution, depending on the situation, to individuals, you may not even want to receive anything. So, yeah.
Well, let's break it down really practical for people that are watching this Orange Couch video. So let's start with an estate plan. You always have these powers of attorney, which means estate plan includes when you're still living, correct? And so why don't we walk through what are those things that you need while you're still alive?
Yeah, Robin, that's a great question. And this is really one of the things that most people don't think about, because when we use that term estate planning, everybody knows, well, when I pass away, I need to have a plan. I need to set in place who receives my assets, and I also need to have an executor or a trustee appointed. But what we forget about is what I consider one of the most important parts, and that's what if we are incapacitated during our lifetime. And one area where that really stood out to me was during COVID. And, we all heard on the news how people were not being able to go in to see their loved ones while they were in the hospital, and people were passing away in the hospital without anybody there. And part of that was because of the disease, but a large part of that was because they didn't have legal access. So there wasn't a power of attorney allowing the doctors to talk to that person. There wasn't a HIPAA authorization allowing those people to have conversations with the medical professionals. There wasn't an advance directive, and so legally the medical professionals could not allow them to be a part of the process, which, in retrospect is really sad. And, we tried to get into court to get judges to appoint, agents for those folks, but the courts closed.
Yeah.
So without the courts and without the powers, we had a big problem.
Yeah, and Doug and I both serve on a hospital board of a local hospital here, and we both know that those hospitals are requiring these medical directives, right? So there's two types of that. Could you explain what a medical directive does?
Yeah, so there's really, in Virginia, there's three different things that we deal with. One is, who are your decision makers? And so we deal with that in a medical power of attorney. The other thing that the medical professionals are really concerned about is, do you have a HIPAA authorization, which just identifies not only your decision makers, but other people who you might want to include in receiving any information about your care. And the reason the medical professionals are concerned about that is because if they share our information with anyone else, it's a $500,000 fine and they lose their job. And then the third one is often, misunderstood, but we call them advanced medical directives. They deal with end of life, and at end of life, sometimes people are in a situation where, internal organs have shut down and they need to be on artificial life support. And if they don't have that heart-lung machine operating on their behalf, it's questionable as to whether they would survive. But question is, who pulls the plug and when?
Yeah, and I have to tell you, just from a personal standpoint, it sounds like something for other people, but I actually had to, with my father, I had to make that decision, and it was very, very difficult. So let me just tell you, do it in advance.
Absolutely.
That's the key word, because you don't want to have to go through that if you've not thought it through with your parents or your spouse, because it's a very difficult decision to make. But if it's been made ahead of time, it makes it a lot easier than it did for me. Let's now transfer into that subject that's even more, a little more important, is that what happens if I die? Property passes three ways: contract, by law, or by will. Contract would be an example of, you got a life insurance policy and you name the beneficiary, automatically goes to that beneficiary. An example of law would be joint ownership with right of survivorship. If I own a house with my wife, Kathy, and I pass, boom, that house goes to her. So a lot of things occur in those two areas, but let's talk about the third area, a will.
Yeah, and so, the challenge for everybody is to understand really what's the best for me, what's the best plan. So that's why I know, Robin, you do this with your clients. We sit down and we talk through. Every family is a little different and they have unique objectives and priorities and concerns. So is a will appropriate? Is a trust appropriate? Is a transfer on death designation appropriate? What's the best for that particular client? So depending on the client, that's kind of where we're going to end up going. But there's some real distinctive differences. Transfer on death designations avoid probate, assuming that the designation is still, the person you designate is still alive at your death. Wills do not avoid probate, and that's commonly misunderstood. So if you have a will, you're going to go through probate, which in Virginia means a 1-year delay in distribution.
Yeah.
A cost of probate, and then it's public record. So those are some of the things that we talk about.
Yeah, Doug and I recently had a friend and a mutual client who passed just recently, and we experienced that because I was helping the spouse, and pretty much everything had been put into the trust, but there was a couple of other assets that weren't. And what we're finding, and you could explain this, is that we're looking at a delay to get access to the money, and got to go through the local clerk of the court, and got to wait a year. So why is that?
Well, in that case, this particular client had a trust, but they didn't fund it. They didn't put the assets into the trust, with the exception of a few things at any rate. And so in this case, as you're saying, we've had to experience, a particular asset that went through that probate process. And the reason it has to wait a year is because by law, creditors have an opportunity for 1 year in which to file a claim. So the courts don't really want assets being distributed out to beneficiaries until that year has passed. Yeah.
So let's get really, really practical. When is it that I need a trust, a revocable living trust, and when is it that I can just probably, a will suffice? I get that question all the time.
Yeah, and that's a great question. And I'm a lawyer. It all depends, right? Well,
economists, lawyers, yes.
Yeah, but what's interesting is it doesn't depend on the law so much as it depends on the client. So some of our clients have relatively modest estates, but they still want a trust because they don't want their children to have to go through that probate process. But in general, what I look at is, we can use transfer on death designations and that type of a way to get assets to beneficiaries in smaller estates. So generally, we'll look at that. But what I like to look at is, do they have real estate? Do they have real estate in different cities? People don't realize if you have assets in Chesapeake and you also have them in Charlottesville, Virginia, you're going to have probate in both cities, never mind different states. So you want to avoid probate in different states, you should have a trust. If you have business interests, you should have a trust. If you have blended families, so if you have children from a prior relationship, very important, very complex, very difficult, but a trust is really, in my opinion, the only vehicle to really help in that kind of situation.
And I have seen them over the years just so easier and transfer from a financial planning standpoint. Boy, it's easy to transfer to the spouse, easy to transfer to the kids that are inheriting the money. Don't have to go through the court system, the clerk of the court, don't have to wait. The money's right there. And from our standpoint, from the financial planning standpoint, the revocable trust is a way to go. I think the final area that I see on a regular basis is that surviving spouse. So many times that surviving spouse has children, adult children, and those adult children sometimes have needs themselves. And I always encourage that surviving spouse to say, look, your needs come first. You've got to take care of yourself. And I think that's an area of how do you protect that senior aging parent today?
Oh, great question there too, Robin. Yeah, we see the same thing in our practice all the time, and it gets a little bit complex sometimes, but for the most part, I mean, it all comes down to how you structure your plan. So if you do a plan in advance, you can actually plan for the protection of surviving spouses and also for children and other beneficiaries. And we do that by creating what I call a sub-trust. If it's to a spouse, it might be a marital trust, we call it. That can't be changed, it's irrevocable, but depending upon the plan, that surviving spouse can either have complete access or restricted access. And then you appoint somebody independent sometimes, not always. Sometimes it's the spouse, sometimes it's somebody independent to be the trustee to oversee it. So that's very, very important.
It's kind of interesting. You can all see that we could probably talk for a long time because we've been doing this so long and we've known each other. So we trust this was helpful. Please, send us some questions that you might have. We'll do it again. I think what we've got here is Doug's coming in and doing a workshop here on, I believe it's December the 5th. And it's a Thursday. We have it here upstairs if you'd like to come. It's about protecting the family legacy is really what the subject matter is going to be. So I'm really excited to have him. He's just an excellent attorney, worked with him many years. And Doug, any final you'd like to share?
No, I just appreciate working with your team so much. You got a fantastic team. It's good to see 40 years prior when we used to talk about this, and now, sure enough, you've built that team.
We were only, 20, something like that? Well, much younger than that.
I was like 15.
That's true. Thank you for listening, and I hope you appreciate it, and please give us a call. Thank you.